I'm Ben Meiselas from Legal AF, joined by Karen Friedman Agnifilo. Karen, a very aggressive, powerful motion filed by New York Attorney General Letitia James in this civil fraud case against Donald Trump, his adult kids, other than Ivanka. She was dismissed by the appellate division, as well as the Trump organizations and various businesses that still remain defendants in this case. As of now, this case is still set for trial in October. We previously reported the dueling summary judgment motions that were filed. One was filed by the New York Attorney General's office. The other was filed by Donald Trump and the other defendants, like his kids, Don Jr.'s adult kids, Don Jr., Eric. But here in this motion that was just brought by New York Attorney General Letitia James, she's seeking sanctions against Don Jr. and Eric. And while the monetary amount is not in the swing of things that massive in terms of the fact that she's suing for at least $250 million. So she's only seeking $20,000 worth of sanctions in this motion. But it's more of the principle, I think, of calling out the frivolous nature of these filings by Don Jr. and Eric, and frankly, everybody. But she points out that, look, they're just regurgitating arguments that they've already lost on these as a matter of law. Karen, to take us through what's going on here.
So don't forget, this is the case that was there was a companion Manhattan DA Alvin Bragg criminal case, and it has to do with the Trump organization, Donald Trump, Don Jr., Eric, and Ivanka, who has now since been dismissed, that they either overvalued or undervalued all of their assets, just flat out objective lies, right? Oh, my apartment, things like an apartment is worth, $10 million when it's real, he says it's worth $10 million when he wants a loan on the apartment, or it's worth $2 million when he wants to pay taxes on it. He wants to pay less taxes on it. So depending on on how he feels, literally, he will just say the same thing is worth different amounts for different purposes, and then lies about things on the record like, oh, it's a 10,000 square foot apartment when it's actually a 2,000 square foot apartment. I mean, really just blatant objective lies and fraud. And so there were two cases that were going parallel investigations, a criminal one and a civil one. And the civil one is going first while the criminal one by Alvin Bragg is on pause. And he's going to trial October 2nd. And in the course of this case, like any other case, there are pretrial motions that are made. There are motions to dismiss. There are motions for summary judgment. There are all kinds of pretrial motions that exist. But what Letitia James did in this particular case is she asked the judge, Arthur Angoran, for $20,000 sanctions total against Don Jr. and Eric because they've continued to raise previously rejected arguments, and they are, quote, frivolous and sanctionable, and cited something that the court had said previously, which was that these are sophisticated counsel and they should have known better than by doing this. And what Letitia James said was there were five that were previously rejected arguments by the court and have been raised again and again. And they're arguments that are based on a lack of legal or factual basis. She cites that in November of 2022, the defendants filed motions to dismiss, and the courts rejected those arguments for a second time. So that means they had already been raised and rejected. And then in November of 22, they filed the same arguments that were frivolous and were rejected a second time. And then they appealed. They appealed to the appellate division first department, which is the first level of the middle level of appeal for New York state courts. And they were again rejected at the appellate level. And so now they're raising it again in now what's called a summary judgment motion in a case where the trial is starting October 2nd. I mean, it's kind of outrageous, right? You can't just, keep making the same thing that the court has said is a frivolous motion without merit merit, and that counsel should know better. You're sophisticated lawyers. So I think that they will be sanctioned. It's a waste of court time and resources. It's a waste of prosecutor, of the attorney general's time and resources. And, but it just also goes to show they have nothing else to say but to dust off old arguments, right? Because they just have nothing new to say, nothing else to say. They're being backed into a corner at a certain point when the facts and the evidence is against you. You're backed into a corner, and they're getting squirrely, and they don't know what else to do other than to keep regurgitating the same old things over and over again. So I think we're going to start seeing sanctions, and I think we're going to start seeing, the court is going to lose patience with them. And, frankly, it surprises me that they would raise this again, because all this will do is alienate the judge. All this will do is, if, you think you're going to ingratiate the judge. I mean, the judge is, you don't want to frustrate the judge, so that when you do have a substantive, legitimate motion to make at some point during the trial or later on, you don't want the judge to be so exasperated with you because you make these motions, and you don't certainly want to be held in contempt or be sanctioned. And money is money. It might not be the most money in the world, but $20,000 is not nothing, right? So I guess, though, if you're using money that you fundraise off of to pay your legal bills, who knows? Maybe you don't care. But that's what's going on here. But if this case goes October 2nd, that's going to be definitely one to pay attention to and one to watch, because that will be a huge sweeping case that she's seeking at least $250 million, depending on how that case goes, depending on how the witnesses do, depending on if the defendants testify. I could then see Alvin Bragg bringing a criminal case as well, because this is just flat out fraud that went on in this particular case.
That's why I think it's brilliant that Manhattan District Attorney Alvin Bragg, the way he sequenced this was something that we talked about here on Legal AF, and we got a lot of initial grief for it many, many months ago, may have been over a year ago, where we were talking about strategically where cases were being brought, why they were being brought. And now you have all of this additional data in the form of, we did a whole video on it here on the MeidasTouch network, the deposition, this 450-page deposition transcript of Donald Trump just, I think, incriminating himself. And now Manhattan District Attorney Alvin Bragg has that entire body of evidence. What we see here, though, is what I've been referring to before as MAGA lawyering, where the same arguments that they think works in their right-wing echo chamber completely backfires when it's in a court of law. So perhaps the lawyering part should be removed from the statement that I just made. It's just being MAGA in a courtroom. And look, if you want to go to Judge Arthur Engoron and say, look, here's the evidence, the statute of limitations, here's the claims, like, that's fair. Like, I'm okay dealing with sophisticated, real arguments. But as Justice Arthur Engoron said in the preliminary hearing motion many, many, many months back, where he granted the Financial Monitor to oversee the Trump business, he goes, Trump hasn't put forward a scintilla of evidence, yet alone admissible evidence. Instead, in the preliminary injunction motion, like in these dispositive motions to dismiss that were just filed, the same arguments were made. Number one, saying that New York Attorney General Letitia James lacks standing to bring the action. Point two, the New York Attorney General is without capacity to bring the suit. And point three, that the fraud claims are barred by documentary evidence and fail to state a claim. And that refers to the, as Donald Trump calls it in the deposition, the worthless clause, which is the disclaimer, which does not say what they claim it purports to say. And really what the worthless clause is it is worthless. It doesn't render what the financial statement misrepresents worthless. It still is fraud when you lie. You can't just say, ha ha ha, I tricked you, though. That's just not the way it works. And by the way, that's not what the disclaimer even says. And so I think 20,000 is a strategic amount. If it was anything in the hundreds of thousands of dollars plus, I think that there is a fear that it could derail the trial date with appellate division proceedings and motions to stay and all of these things. So I think that New York Attorney General Letitia James is like, Judge, you can slap them on the wrist here. The big issue of accountability is this trial date, which is taking place in October. Don't move that. We're ready to go to trial. And not only are we supremely confident that we are going to prevail and defeat their motions to dismiss, but their motions to dismiss are so bad, Judge, it's frivolous and should be sanctioned. So we will cover this more, of course, as we get closer to that trial date. But this is a case that could shut down the Trump organization and Donald Trump and Eric and Don Jr. from doing business in New York. I think that New York Attorney General Letitia James is going to be seeking billions of dollars in damages when all said and done. We will keep you posted, of course. Hey, check out patreon.com/MeidasTouch. Have you seen the Karen Friedman Agnifilo origin story and Michael Popak origin story? Go to Patreon, patreon.com/MeidasTouch. Become a member, help support the MeidasTouch network that way. Otherwise, just hit subscribe, share these videos, and make sure you subscribe to the Legal AF podcast. Thanks for watching this duet by Karen Friedman Agnifilo and Ben Meiselas. Have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.